I'm Sam Roberts of the New York Times, and welcome to the New York Times Close-Up. In October of last year, President Trump, backed by his Republican Senate majority, was able to install Amy Coney Barrett as the newest Supreme Court justice. She filled the spot vacated when Ruth Ginsburg died. It was a move meant to cement the conservative wing of the Supreme Court, which had been bolstered when Brett Kavanaugh became a justice in 2018 and Neil Gorsuch in 2017, all appointees of President Trump. During its current term, the court issued decisions on a range of major issues, including voting rights, the Affordable Care Act, amateur athletics, evictions, unions. But with the end of the Supreme Court's term, how far has the court drifted to the right? Or has the installation of the three Trump justices had less of a conservative impact than the left had feared? We're joined by Adam Liptak, who has been reporting on the Supreme Court for the New York Times for 13 years. In a recent column, he came to the conclusion that the court's decisions were, in his words, fluid and unpredictable. Adam, welcome, and thanks for joining us. Fluid and unpredictable. What does that mean? And let's say, were you surprised by the turn of the court over the past term?
It's great to be here with you, Sam. And for most of the court's term, we didn't get what, from the perspective of the left, was this conservative 6-3 juggernaut. The number of 6-3 cases was fairly low. There were a number of unanimous cases, including big ones that you mentioned on student free speech and gay rights and religion and athletes. And while the three Trump justices emerged as the center of the court, they would on occasion, and not super infrequently, join the three-member liberal wing to produce majorities, or combinations of them did. On the other hand, on the very last day of the Supreme Court term, last Thursday, the court issued a major voting rights decision that, from the perspective of voting rights advocates, was a real blow to what is maybe the central political issue of our day about the state of our democracy and whether many states controlled by Republicans can impose voting restrictions. And the court essentially gave those voting restrictions a green light by the 6-3 majority that liberals feared would use its power in all kinds of cases. It turned out it used its power only in the most important case.
So let's talk about that for a minute before we look at the overview of the situation. In that case, and looking at the Electoral College and looking at what states are doing in terms of voting rights legislation or eliminating voting rights in effect, are we gutting the Voting Rights Act, the so-called crown jewel of the civil rights movement of 1965? And by doing so, does that mean the greater likelihood of electing more conservative presidents, more conservative senates, and therefore creating a more likelihood of a conservative supermajority self-perpetuating on the Supreme Court?
The short answer to all of that is probably yes. The Supreme Court has already once taken the heart out of the Voting Rights Act in a 2013 decision called Shelby County. What was left of the Voting Rights Act was a provision that allows lawsuits after the fact to challenge voting restrictions if they result in a disproportionate impact on minority voters. And the Supreme Court, so that's the tool that was left to challengers of voting restrictions. And as you know, Sam, their bills and laws on voting restrictions are just blossoming around the country in red states. And the court really neutered the ability of people to try to challenge those laws as racially discriminatory. So that's not to say that minority voters and Democratic voters won't continue to show up at the polls. And it may be that these burdens won't stop them, and in some cases might even energize them. But the goal behind the restrictions is, as you say, a partisan one. and a 6-3 Supreme Court majority with 6 Republicans in the majority, 6 Republican appointees, 3 Democratic appointees in dissent, seemed to be bolstering this Republican conservative project.
How does the Supreme Court, how do the justices rationalize that? Obviously not, I assume, from a partisan point of view. They're looking at it constitutionally. So how do they say that people can vote, that we don't need civil rights protective legislation anymore? How do they explain that in terms of constitutional protections?
So I'll give you 2 answers at different levels of generality. At one level, the high level, the court majority believes that the Constitution commits decisions on how to run election systems to state legislatures, and that the federal courts should be reluctant to get involved in something that the Constitution says is generally for the states. And then more particularly, they explain, to not universal satisfaction, that the words Congress chose in the Voting Rights Act need to be interpreted in a certain way, and didn't give challengers carte blanche to say anytime you make it a little bit harder for a minority voter to vote in Arizona, say, that results in the voting restriction getting struck down.
So are these decisions by the court still subject to potential congressional legislation? If voting rights legislation passes Congress, does that in effect overrule the Supreme Court?
Yes, this is a statutory decision. It interpreted what Congress said. If Congress wakes up tomorrow morning and said, you know what, you're wrong, that's not what we meant, here's what we meant, here's some new legislation, they could easily bolster the Voting Rights Act. And there are, major pieces of pending legislation in Congress that seem to have little chance of success, partly because Joe Manchin's not wholly on board, and largely because the filibuster rule requiring a 60-vote supermajority remains in place.
I was surprised at the fact that, as you mentioned in your story in the Times, there were so many unanimous opinions by the court when the court seemed so divided. Why would that be?
Well, the court is not just one thing. The court has a docket full of difficult legal questions, many of them without any particular political tilt. And the court works hard to resolve questions so that the lower courts know what to do. And in some sense, it's not so much which answer is right, it's that you need to have an answer. And this is maybe underreported in the press, but unanimous decisions are not unusual in the court. It was unanimous, I don't know, 46% of the time this last term, and that's not especially out of line. They don't tend to be the biggest cases, although this term, 9-0 and 8-1 cases did arise in some fairly big cases. So when you take the big partisan cases out, and when you take the big business cases out, and you're looking more at social issues or questions that just need a resolution, like can schools discipline a student for social media posts, the court tries hard and in good faith to come together.
This may be a technical question, or at least technical to me, but why were there such a small number of decisions in argued cases that were signed opinions? The
court's docket has been shrinking for a long time, and there are a bunch of possible reasons for that. Last year, it went to the lowest number since the Civil War, and that was a function of the pandemic. They canceled a bunch of arguments. They started having arguments by phone. And this year, my best understanding, but it's confusing why it should have remained at that same low level. It's partly that it's harder to work during the pandemic. It's partly that anytime you have a new justice on the court, and Justice Barrett didn't join until a month into the court's term, you kind of have to get that new justice into the mix and up to speed. But still, for a 9-member court to issue 54 decisions, it's preposterously low.
Next fall, we've got a lot of big issues coming up: abortion rights, gun rights, government aid to religious schools, now libel perhaps on the court's agenda. What's the likelihood of major action on cases like that?
Well, the abortion case takes head on Roe v. Wade, the decision that established the constitutional right to abortion. So that is as big as it gets. I mean, that's the issue that most people associate with the court. And I would have thought the court would have moved a little slower in chipping away, perhaps, at abortion rights, but not taking Roe head on. So that's huge. Also, the court has, in more than a decade, not returned to the question of what the scope of the Second Amendment is. We know the Second Amendment protects a right to have a gun in your home for self-defense, but the court has never told us about whether you have a right, a Second Amendment right, to carry your gun outside the home. So those cases are huge. We may well have the affirmative action case from Harvard. We have another case on aid to religious schools. So, you know, in my business, the term, this is a blockbuster term, rolls easily off the tongue almost every term. But there's no exaggeration that the next term is going to be big, big, big.
You say this is not as much or not so much the Roberts court anymore, that he is still in charge, but not as much as he was. Let me ask you probably a silly question. What does a Chief Justice do?
The Chief Justice gets only one vote like everybody else. So in a sense, he's the first among equals. But he does have a very important additional power. He gets to assign the majority decision when he's in the majority. And that can really, giving the opinion to someone who's going to write it narrowly or broadly, somebody who's going to pick up more votes or fewer votes, someone who's going to hang on to a majority or not, is terribly important. And the court, the Chief Justice also has some administrative powers about setting arguments and when to hear them, and sets the tone at the court and is the public image of the court. So when Chief Justice Roberts, for instance, got into a tussle with President Trump about whether there are Obama judges and Clinton judges and Bush judges and Trump judges, that made a major statement about judicial independence. But Chief Justice Roberts, you know, for years and years was not the swing justice. Justice Kennedy was. Then for one term, he was both the Chief Justice and the swing justice, the justice at the court's ideological center. And that was an enormous power that no Chief Justice has had since 1937. And now these Trump justices come in, and we now have a soft middle of the court with the three Trump justices and the Chief Justice. And he's been outflanked on the right. So there are really five justices to his right, but not very far to his right, which is why, as you started by saying, Sam, that I said that this is still an institution that's fluid and in flux.
Fluid and in flux, and as you say, going to be some very interesting decisions and possibly profound and pivotal ones coming up in the fall. Adam Liptak, the Supreme Court correspondent of the New York Times, thank you so much for joining us. And coming up next, another debacle at the city's Board of Elections. Welcome back. New York City's first ever ranked choice voting primary has finished. Eric Adams has unofficially been declared the winner, but the drawn out vote count is still not final. This process was engulfed in controversy right away, the release of vote totals that were inaccurate and quickly retracted. It was reminiscent of the 2016 primary election when over 100,000 Brooklyn voters discovered they had been purged from the voting rolls. The current vote counts took place at the New York City Board of Elections, a city agency with a contentious history. The board has had a nepotistic and dysfunctional record, according to Times investigative reporter and Pulitzer Prize winner Brian Rosenthal, who joins us today. Brian looked at the board's history with Dana Rubenstein, Andy Newman, Ann Bernard, and Ed Shanahan. And this Board of Elections 50 years ago, the Times called at best a semi-functioning anachronism. Now, I remember, not personally, of course, Boss Tweed said it really doesn't matter who controls the voting, it matters who controls the counting. Well, Brian, how is it that this Board of Elections that was a semi-functioning anachronism 50 years ago is still doing the counting exactly the same way?
Yeah, well, we actually had a joke when we started working on this project, when we were assigned to investigate the Board of Elections. We joked that it was a rite of passage. Every New York Times Metro reporter has to do their story showing all the problems that still exist decades later. And we read Dean Baquet's stories 20 years ago about the same topic. It's a unique situation. There is no other Board of Elections in the country like this. And it has lasted for so long because the people who are empowered to make changes like it. They don't want to make changes because it's good for them. The people that control the board now are the political parties, and the political parties are the politicians who are in charge of potentially making changes. And there is an additional complication, which is that this unique structure is in the state constitution. So if you did want to make a change, you'd have to go through a structural change, at least. You'd have to go through a constitutional amendment, and that's a lot of work when, again, a lot of people in power do like it.
Is it true that originally, when this was put in effect, a number of Democratic and Republican appointees, at least on the surface, it was intended to ensure impartiality?
Yeah, and at the time, it was actually seen as a really innovative, creative solution. And the idea was, by giving all the power to the political parties equally, you would ensure that both sides are equally represented at the table. And so nobody could cheat, nobody could get ahead, because they would both be there counterbalancing each other. And that was seen as better than having one person who might have a bias and might control the process. Unfortunately, the way it's worked out is that what it's meant is that the political parties have put in place people who their only qualification is loyalty to the party, and they have no knowledge of how to run an election. And so we see these problems over and over again.
Other than the fact that obviously it provides a great deal of employment, and possibly even more in terms of awarding contracts and things like that, how does this benefit the political parties, especially when these days political parties really don't have that much power at all?
Well, again, at the New York City Board of Elections, every single position is essentially chosen by the political parties. And it's usually chosen through the borough presidents. So it's a crazy system. The Board of Elections, down to the computer programmers, have to be divided, one Democrat, one Republican, and divided into borough. And so if there's a computer programmer happens to retire, and that person happens to be a Democrat from Staten Island, then their replacement must be a Democrat from Staten Island. That is how the system is set up. And so that's not a normal job application process. The way that works is the Democratic Party of Staten Island and the borough president, who is in charge of that. I guess I shouldn't say the borough president. The party president for that borough finds a Democrat who can do that job. And so they're empowered to hire everybody, and they're also empowered to choose the people who make decisions about whether candidates have all of their petitions filled out in order to run. It's a huge benefit to incumbents. I mean, if you're somebody who's challenging the status quo and you are going up against the establishment, I mean, the establishment literally chooses who sets the rules of the election. So again, there are just a number of benefits for the party leaders.
As you said, political leaders have very little incentive to support any sort of changes or reforms to the current system, but aren't they smart enough in terms of self-preservation to appoint a couple of people who know how to run the system?
You would think, Sam.
I guess that's a rhetorical question.
You would think. And yet again and again, we just see problem after problem. And the people who are put in power, I mean, we did a story, not this latest story, but we actually did a story in the last election that looked at the actual people who were in charge of each department. And you could see the person who was in charge of voter registration was the mother of a former congresswoman. Or congressman. The person who was in charge of election day operations was a close friend of the Manhattan Party chair. I mean, you can go down the line. Every single agency leader is somebody who their main qualification is their loyalty to the party. And so that is just how it has always been, and how it looks like it will continue to be.
And how do they justify turning down support from the supplier of the software? I mean, that obviously they would have had to pay for that, but that just makes no sense whatsoever.
Yeah, we haven't gotten the justification for that. So, there's a new system for voting this time around, a new software that's put in place, and the vendor says that they offered to help and never heard back. One of the things that I think was going on in that time, we know was going on earlier this year, is that there was a leadership vacuum. There are 4 people who run the Board of Elections, 2 Democrats, 2 Republicans. And it goes, there's the top person, and then there's the second person, and then the third person, fourth person, obviously. The first person has been on medical leave for 4 months now. And the third person, that was Michael Ryan, the third person in charge, Pamela Perkins, just decided to retire basically 2 days before early voting began, not exactly at the best time. And so that has left them with only 2 of their top people in power. And that has caused a lot of problems in the organization. It has caused a lot of disorganization. And that may have played a factor in them turning down offers to help, and definitely played a factor in some of the other problems they've had this year.
This may also be a rhetorical question, but where are all the good government groups that have called for changes like this for decades and decades? And why is there no grassroots movement, no galvanizing force that says, enough already, this is ridiculous? Whatever the good intentions were in creating it in the first place, obviously this has not worked. There has to be a better system. And if it takes a constitutional amendment, that's not insurmountable, that can be done.
Yeah, I mean, I think the good government groups are tired. They've been talking about this for a long time. They have not seen any change. And, I haven't actually asked them. I don't want to speak for them, but I imagine that it can be quite frustrating, and you start to lose hope of any change happening. And so, I mean, they have been calling, they've been continuing to call this week, but they also have a lot of other priorities, and this is one that they've been banging the drum on for a long time and haven't seen any results from it.
Brian, I don't understand how 135,000 extra votes could have turned up in the original Tuesday tally. And some of the candidates and even voters knew that there was a discrepancy there, but the Board of Elections did not. I mean, I'm not a great mathematician, but I could do arithmetic.
Yeah, and it's actually a mystery to me as well, because one of the hallmarks of the Board of Elections, as I mentioned earlier, is that there are always 2 people doing any one job, 1 Democrat, 1 Republican. And so what happened here was there was a mistake. Obviously, they left the test results in the system, and those accidentally got added to the actual results. But you'd think if there are 2 people doing that, then if one person makes a mistake, the other person would catch it. But apparently that did not happen here. Obviously, it did not happen. And the people at headquarters who were in charge of then announcing these results apparently just completely missed the fact that there was this enormous change in the vote total. They just, I guess, missed it. So no, we don't really fully understand how they could have missed it, how they could have made that mistake, how they could not have found it. It remains a mystery, honestly.
Obviously, this vote count is still not yet official. What happens from here on?
Well, there are some additional processes that that need to be conducted. New York allows for voters to cure their ballots. So if there was a problem with their ballot, they can fix that problem and make sure that they are voting for the appropriate person. So those votes need to be counted. We also have potential legal challenges. Both of the other leading candidates, Catherine Garcia and Maya Wiley, have preemptively filed legal challenges, preserving the ability to sue. And given some of the problems that we've seen over the past week, it wouldn't be a surprise if they want, if they don't trust the Board of Elections and they want a recount or some other remedy. And so, they have that opportunity. So we might see that and hopefully relatively soon, because it's been already a few weeks since Election Day, but relatively soon we will have it sorted out.
And then we can worry about the fall campaign. Brian Rosenthal of the New York Times, thank you so much for joining us. And for the New York Times and CUNY TV, I'm Sam Roberts.